Hearing the appeal of Peter Fishery and Stephen Fishery against HMRC and HMRC against Andy Fishery.
May it please your lordships, your ladyship, I appear in this case on behalf of the members of the Fisher family, Stephen, Peter and Anne, together with Mr. Rory Mullen, KC, and Mr. Imran Afzal. His Majesty's Revenue and Customs are represented by Mr. David Hewitt, KC, Brenda McGurk, Barbara Belgrano, Ben Elliott, and Amelia Carslaw. In February 2000, Stephen Fisher and his son Peter faced a very real dilemma. Peter, in particular, had developed a successful telebetting business, that is, taking bets over the telephone, through a UK resident company, Stan James Abington, referred to as SJA. However, the UK betting duty legislation had not kept up with technological developments, specifically telebetting. The legislation was operated in practice through a 9% surcharge on punters who placed bets with a bookmaker in the UK. But there was no charge to duty on a bet placed by a UK punter with an overseas bookmaker. Instead, there were criminal penalties under Section 9 of the Betting and Gaming Duties Act 1981, BGDA 81. For example, if a UK bookmaker shared resources with an overseas bookmaker, or an overseas bookmaker issued a document advertising its services in the UK. By March 1991, one of SJA's major competitors, Victor Chandler, had established a company in Gibraltar and was offering duty-free betting facilities to UK punters. Other major bookmakers followed suit. Not until October 2001 did the UK amend the law on betting duty, but by that stage it was too late, and there were no major telebetting operators in the UK. SJA's customers, particularly the regular customers who were most impacted by the surcharge, had been drifting away and placing bets with overseas competitors who imposed a much lower surcharge or offered duty-free betting. SJA's business that it had built up over a number of years was under threat of disappearing. Victor Chandler, the competitor, brought a case in July 1999 seeking a declaration that advertising by teletext was not caught by the prohibition in Section 9 BGDA. And Lord Sales will be especially familiar with that case, having appeared for Customs and Excise and won it in the Court of Appeal. In the Court of Appeal, Sir Richard Scott, the Vice-Chancellor, said as follows, and if I may, I'm not going to take you very frequently to the authorities, but I'll just give you the references. There is a transcript, and you will have them there to save time. Most of the quotations are in our written case there. If I may just read from Sir Richard Scott. The main purpose of Section 9...
Sorry, can we just have the page?
Oh, I'm terribly sorry. Yes, it's Authority 61, page 2394.
Thank you.
The main purpose of Section 9 is to protect the revenue, but that is not its only purpose. The effect of the section, and presumably one of its purposes, is to protect domestic bookmakers from unfair competition from those who operate offshore. An offshore bookmaker who is not chargeable with betting duty will be able to offer a more attractive return to punters than domestic bookmakers can offer. Nothing in the Act prevents domestic punters from placing their bets with offshore bookmakers. But Section 9(1)(b) prohibits the issue, circulation, or distribution in this country of advertisements or other documents relating to the making of bets with offshore bookmakers. As Lord Sales will know, Mr. Justice Lightman decided in favour of Victor Chandler, but then Lord Sales rescued the matter back in the Court of Appeal. SJA was one of the competitors.
I think it's worth just noting that the loss for the revenue at first instance rather precipitated the move away to Gibraltar, because it was thought at that time, during that period between the High Court and the Court of Appeal, that you could be located in Gibraltar and advertise in the UK, which obviously was...
Precisely, which is why by the end of that year there were no telebetters left in the UK. It had all fled before the time that the transfer took place to the Gibraltar Company in the case of SJG, which is the point I'll be coming back to. SJA was one of the competitors of Victor Chandler, and they faced this unfair competition from those who were operating offshore. Stephen Fisher was vice chairman of the Betting Office Licensees Association, and he was involved in representations to the UK government to change betting duty to prevent the movement abroad, but at that time there was no change to the UK legislation. To preserve its business, SJA had no choice but to start operating offshore. Punters would simply not bet with them because they charged betting duty once the punters were aware that they could take duty-free betting from the competitors. Initially, SJA established a branch in Gibraltar which began taking telebets, but only from non-UK punters under a voluntary agreement with Customs and Excise. But as its business was increasingly under threat of disappearing, SJA began from July 1999, approximately the time of the judgment in the High Court in Victor Chandler, to take telebets from UK punters. Had SJA continued to operate through a branch in Gibraltar, no issue of liability under Section 739 would have arisen, as no income would have arisen to a person abroad. But Stephen and Peter were in correspondence with Customs and Excise, who stated that a separate legal entity was needed to ensure the restrictions in Section 9 BGDA were observed. And they also received legal advice from leading counsel that they were potentially at risk of criminal penalties unless they operated through a separate company. They both believed that they risked breaching Section 9 unless they operated through a separate company. That's a finding of the First Tier Tribunal, the FTT, at paragraphs 475 to 480, electronic page 326. With effect from the 29th of February 2000, SJA transferred the Gibraltar branch and the remaining tele business from the UK, together with various assets, to a separate company, Stan James Gibraltar, SJG. At that time, Stephen and his wife Anne each held 38% of the shares in the transferor SJA. Peter and Diane, his sister, each held 12%. It is that transfer by SJA to SJG on the 29th of February 2000, some 9 months after they had started taking bets in Gibraltar, to which HMRC says Section 739 applies. Stephen and Anne subsequently came to hold 26% of the shares in SJG, and Peter and Diane held 24%. His Majesty's Revenue and Customs assessed Peter and his wife Anne on 26% of the profits of SJG for the 8 years from the transfer until they disposed of their shares in SJG, even though Stephen, for example, never received any profits from the company. That's FTT paragraph 90. And Anne had virtually nothing to do with the business throughout this period. She had nothing to do with the business after 1996, and that's FTT 21. HMRC also assessed Peter on 24% of the profits until he became resident in Gibraltar. Diane was resident in Gibraltar throughout and never assessed. Stephen, Anne and Peter appealed their assessment under Section 739. So far as they are aware, they are the only shareholders in a UK bookmaker company who have ever been assessed a tax under Section 739 in respect of these transfers abroad. The First-Tier Tribunal held that Section 739 can apply to a transfer made by a company and to individuals having minority shareholdings in that company and who do not individually control it. They held that it was not possible to separate the main purpose of saving the business from what they regarded as a main purpose of avoiding betting duty. And none of Stephen, Peter and Anne could rely upon the motive defence. Anne, however, had an EU law defence to the tax charge. There are a number of factual points that the FTT found in the Fishers' favour, and I'd like to just identify them. They found that Stephen and Peter had no purpose of avoiding income tax. That's paragraph 502. They had no purpose of avoiding corporation tax.
I do apologise. What paragraph was that?
502.
502. And what page number is it?
Page 329.
Thank you very much indeed. Okay.
No purpose of avoiding corporation tax, paragraph 494, page 328. They found that Anne had virtually nothing to do with the business after 1996, paragraph 21, page 258, and that she entrusted her responsibilities to her husband and son. That's paragraph 199, page 283. She had no motive with regard to the transfer at all. That's paragraphs 507, 515, and 516, pages 330 to 331.
Sorry, could you give the paragraph?
507, 515, and 516. Your Lordships may wish to know that there is a transcript being taken, and copies will be provided.
I prefer taking note myself, it's easier to follow.
But pages 330 to 331. And the FTT also found that the transfer was a bona fide commercial transaction. That's paragraph 543, page 335, and that's relevant to the motive defence. None of these findings have subsequently been challenged by HMRC. On appeal, the upper tribunal reversed the FTT and held first that Section 739 could not apply at all to individuals who individually held minority shareholdings in a company, people who are sometimes referred to by the somewhat inelegant term as multiple quasi-transferors. That was sufficient to dispose of the appeal. The upper tribunal, though, also held that the FTT had erred in not accepting that the motive defence, the second limb of the motive defence, could apply to the Fishers. And also, again, if they needed to do so, Anne and Stephen, but not Peter, could rely on the EU defence. The Court of Appeal, by a 2-to-1 majority, Lord Phillips dissenting on this point, held that Section 739 could apply to multiple quasi-transferors. They added, however, that Anne did not procure the transfer and was not a quasi-transferor and was not liable to tax. The Court of Appeal all held that Stephen and Peter could not rely on the motive defence or EU law arguments.
But, Lord Justice Phillips didn't dissent on the question of quasi-transferor, did he? He dissented on the exclusion of Anne.
Precisely. No, he dissented on, he was of the view that all of the members of the Fisher family were not liable. It was not just on the issue of Anne. He was not with the majority.
He was not with the majority at all.
No. He's very much a dissent.
He would have dismissed the appeal in its entirety.
He would have dismissed the appeal in its
Yes,
entirety. That's right. Yes. Stephen and Peter appeal against this decision, and HMRC have appealed in respect of Anne. There are 3 issues in the appeal, and it's been agreed that though there are appeals and cross-appeals, Counsel for the Fishers will open on all three issues. HMRC will then respond on all three, and if there are any new issues on EU matters in our response, HMRC will have the final right to deal just with those EU issues. The issues I'm certain you're aware are, firstly, the multiple quasi-transferor issue. Can Section 739 apply at all to a transfer by a company in which individuals have shares and are directors, but do not individually have control over the company? And in particular, can the section apply to Anne, who played no active part? Second, the motive defence. Can Peter and Stephen, and if necessary Anne, rely on the motive defence? And we will focus on the second limb, though our arguments also extend to the first limb as well. Third, the EU law issue, and which applies to Anne only. If it please the Court, we have divided this matter between ourselves. Mr. Afzal will address you on the first issue. I will then return to address you on the motive defence, the second issue, and Mr. Mullen, KC, will address you on the third issue. So if I may, I'll pass over to Mr. Afzal.
Yes, thank you.
My lords, my lady. I'll start, if I might, by giving a brief overview in a few sentences of the key propositions which I intend to make, and then I'll elaborate on each one of those. The first proposition is that Section 739 only applies to transferors. That can be seen from Majesty, and to foreshadow what I'll be saying in a moment, there is an alternative analysis coming out of Congreve, the earlier House of Lords case, in which it was held that a person can be liable if he or she procures a transfer, but I'll show in light of Majesty, where it was very clear that the legislation only applies to transferors, if someone is to be liable as a procurer or on some other language one uses along those lines, it is because in substance, in reality, that person can be viewed as having made the transfer. And so the ultimate question always is this individual a transferor in reality? The second proposition will be that as a matter of principle, a minority shareholder cannot, save for one exception where he or she holds a proxy over someone else's shares taking him into a majority, save for that exception, a minority shareholder cannot procure a company to make a transfer, i.e. such an individual cannot be a transferor in reality, and therefore Stephen, Peter and Anne, all three of them, should not be liable. The third proposition is that there are additional factors which reinforce the fact that minority shareholders shouldn't be liable. So I say it follows under the natural interpretation of the legislation following from Majesty, that was proposition 2. But also, if one were to accept, in principle, minority shareholders can be liable, the consequence is one can have multiple individuals being liable under 739, and that gives rise to a number of difficulties. Difficulties with the apportionment machinery, difficulties with the motive defence, and difficulties in drawing lines. And I say all of that reinforces the fact that minority shareholders can't be liable. And then my fourth and final proposition specifically relates to Anne, and is that in any event, the alternative or further reason, for us it's a further reason, but it was the reason given by the Court of Appeal in relation to Anne as to why in any event she's not liable, namely she didn't do anything. We stand by that. So even if I fail in all my earlier propositions, in any event, Anne should succeed. In the course of my submissions, at the appropriate junctures, I'll deal with points made by the Court of Appeal and made by HMRC in their written case. One argument advanced by HMRC, which naturally might seem to go to the first proposition, but they've left it right to the end of their case on this issue, is a suggestion that Majesty is no longer good law. Maybe that they've put that right at the end because they don't place as much emphasis on it. I propose to also deal with that at the end of my submissions, but if you'd like me to take it earlier, please do say, and I can deal with that earlier on.
Can I ask you just one thing?
Please, my lord.
There's a lot of territory that needs to be covered by the three of you between now and 2, do you have a time frame in mind? Because we need to watch how many questions we're putting to you to make sure we don't eat into the time that Mr. Baker and Mr. Mullen require.
Thank you, my Lord. The idea was that I should aim to be done by 12, but latest 12:15 if need be.
Yep.
Mr. Baker would aim to be done by lunchtime, and Mr. Mullen half an hour after lunch.
That's very helpful. Thank you very much.
So starting with the first proposition that Section 739 only applies to transferors, the key case is of course Majesty, but it's helpful to draw out a couple of propositions from the earlier case of Congreve, or a couple of passages rather, because the alternative analysis in Congreve was considered to be good in Majesty, and it's to do with procurers. So in Congreve, the primary decision, or the basis on which the House of Lords found decided the case, was that non-transferors can be caught. That was overruled in Majesty. But there was an alternative which was discussed most clearly in the High Court by Mr. Justice Wrottesley and in the Court of Appeal by Lord Justice Cohen. I'll draw your attention, if I may, to 2 or 3 relevant passages. With Wrottesley J in the High Court, the relevant page is 1263, and I'll read this out rather than turning it up. His Lordship said, "The section does not deal with the case of an individual who escapes tax because of a transfer which some other person makes. The use of the words by means of fits this interpretation." And that's the words by means of transfers of assets, which appears in 739. And then against that background, having held that it only applies to transferors, at page 1264, his Lordship said, "I think that a person who, by owning all or practically all of the capital of an investment company, is able to bring about such a transfer, as is referred to in the section, is, for the purposes of such a section, a person who has avoided tax by means of a transfer." So given that his Lordship, starting from the proposition that you have to be a transferor to be liable, one can see that when he talks about someone who owns shares in a company, all or practically all of the capital of a company, bringing about a transfer, his Lordship must have been considering that such a person was in reality a transferor, because he had just held that the section only applies to transferors. And I flagged that because that is the origin of the so-called procurer or quasi-transferor concept. Now, Lord Justice Cohen in the Court of Appeal, he held the opposite. He held that the section is not limited to transferors. He started by saying, well, he noted at page 1273, I should say the page references I'm giving are the bundle ones as opposed to internal document references. His Lordship said at page 1273 that it was the argument for the taxpayers that the individual must transfer the asset. He analysed that at length and ultimately concluded at page 1275, for the reasons he'd given, we agree on this point with the conclusion of the commissioners. So he rejected the argument that it's limited to transferors. But he then went on to say, and this is at page 1275, but even if we were prepared to accede to the argument that the preamble connoted activity by the individual concerned, we think this condition would be fulfilled if the execution of the transfer were procured by the individual concerned, even though it was not actually executed by him or his agent. Now, once again, given that his Lordship had framed the issue at 1273 in terms of whether this was limited to transferors, he then said, no, it's not limited to, he said, we reject that argument, because even if we had acceded to the argument being that it was limited to transferors, he says we would have been prepared to accept that procuring a transfer suffices. So once again, given the hypothesis on which this statement at 1275 was made about procuring, the hypothesis being that the argument was correct, the section was limited to transferors, one can see that in reality it must be that if someone is liable as a procurer or a quasi-transferor, it is because he can be viewed in reality as a transferor. The House of Lords didn't comment on the procurer concept, so I won't turn to any passages in the House of Lords decision. I will now turn to Majesty. The facts, in a nutshell, were that the individuals who were assessed had no hand in the transfer of assets which had taken place. These were settlements which had been created by their relatives. They were amongst the class of discretionary beneficiaries, and HMRC sought to assess them, or the revenues that then were, sought to assess them under Section 739. Here, I will spend perhaps 5 or 10 minutes identifying some of the passages, because this is, in a sense, part of the key battleground between the parties. What precisely was the House of Lords saying in Majesty? And with respect, we have to disagree with the majority of the Court of Appeal and with my learned friends opposite. Most of my focus will be on the speech of Lord Wilberforce, but his opinion represented the majority. For your note, Lord Salmon at page 1458 simply said he agreed with Lord Wilberforce, and Lord Keith at page 1465 agreed with both Lord Wilberforce and Viscount Dilhorn. Now, the starting point to note in Lord Wilberforce's speech, once again, I won't take you to this page, but I'll give you the reference. It's at page 1437, and it's at C on the side as it starts. It's the way in which his lordship framed the issue. He noted that the taxpayers' overriding contention was that they could not be liable under 739 because the transfer of assets were not made by them. So in fact it says the taxpayers dispute each of these claims, and additionally, as an overriding contention, submit that Section 412, which is a predecessor to 739, does not apply at all to a case, whereas here the transfer of assets was not made by any of them, but by other persons. So that's the taxpayer's argument. His lordship then says that Mr. Justice Walton considered that he was precluded from accepting the overriding contention by the decision of this House in Congreve. So, and then later on the same page at F, his lordship says, the House is invited, if necessary, to depart from its previous decision in Congreve. So that's how his lordship has framed the issue. The taxpayers are saying it's limited to transferors, persons who have made transfers. It was said that Mr. Justice Walton, there'd been a direct appeal from the High Court to the House of Lords in Majesty, had felt that he couldn't accept that contention because of Congreve, and so the issue is, was Congreve rightly or wrongly decided? Which would suggest, and this is borne out by later passages, that if Lord Wilberforce was going to find that Congreve was wrongly decided, presumably it's because he accepted the overriding contention that the section is limited to persons who make transfers. His lordship then, over a number of pages, analysed the revenues argument that it had discretion as to who to assess and in what amounts. So the revenue said, well, although there's a number of there are multiple beneficiaries here, we're not seeking to recover more than 100% of tax, but we can decide which beneficiaries to assess and in what amounts. And Lord Wilberforce said, well, the practical consequences of that would be, to quote him, frightening. He said that at page 1440 at D. And more fundamentally, he said at 1440E, it would be contrary to constitutional principle if the revenue had such a discretion. It was against that background of noting those practical difficulties and the constitutional objection that his lordship considered whether Congreve was correct or not. The first point his lordship made was, well, in light of that discussion he had just had, if Congreve was correct, it would produce arbitrary, unjust and unconstitutional results. And he said at page 1442G that must cast doubt on the decision. And then he turned to the possible interpretations of Section 739 as it now is. And this is at page 442H, and it says there are undoubtedly two possible interpretations of Section 412, particularly having regard to the preamble. The preamble is now what's contained in subsection 1 of 739. The first is to regard it as having a limited effect to be directed against persons who transfer assets abroad. who by means of such transfers avoid tax and yet who manage when resident in the UK to obtain or be in a position to obtain benefits from those assets. For myself, I regard this as being the natural meaning of the section. This avoids all the difficulties discussed above. No difficulty arises from cases of multiple transferors, which I'll comment on in 2 moments. He said the second is to give the whole section an extended meaning so as to embrace all persons, born or unborn, who in any way may benefit from assets transferred abroad by others. This follows from the Congreve interpretation. This I regard as a possible but less natural meaning of the section. So pausing there at this stage, Lord Wilberforce is just looking at the interpretation of the section without looking at other considerations. And he says the most natural interpretation is that it's directed against persons who transfer assets abroad. So that, of course, is transferors. One point flag here is his sentence, no difficulty arises from cases of multiple transferors. So what did his lordship mean by that? It isn't, and that's at the top of 1443, paragraph A. Well, it's not entirely clear from the text itself, in the sense that Lord Wilberforce doesn't explain what he means. One view, which was expressed by Mr. Justice Walton in the later case of Pratt, and for your notice at page 1373 of the bundle, is that Lord Wilberforce was simply saying the question of multiple transferors wasn't a live issue in this case. Now, that is a possible interpretation, but given that Lord Wilberforce was trying to work out the correct interpretation of the legislation and whether to depart from existing House of Lords authority, with respect, it would seem surprising if you would simply ignore something which is relevant to how the section works, simply on the basis that it's not a live issue on the facts. It seems to me, in my submission, more likely that his lordship was saying that cases of multiple transferors do not create problems. By no difficulty, he meant there's no problem with the case of a multiple transferor. Now that could be on one of 2 bases. It could be you can have multiple transferors, there's no problem, no issues arise, or they don't create problems because you're not allowed to have, you can't have multiple transferors as a matter of principle. And in my submission, his lordship must have meant the latter because he simply can't have meant the former. He can't have meant, in principle, you can have multiple transferors, but no difficulties arise, because he had just spent a number of pages explaining the difficulties that would arise if multiple beneficiaries could be liable. And by analogy, the exact same difficulties apply if you have multiple transferors. His reasoning applies mutatis mutandis. So it's extremely unlikely that having spent 3 or 4 pages discussing those problems, that his lordship had suddenly forgotten at this stage about all of those problems. So
in that discussion above, had he talked about multiple transferors?
He talked about multiple beneficiaries being liable, and the problems, in a nutshell, were this. Because there was no apportionment mechanism, or there was no mechanism to work out who was to be liable out of those multiple beneficiaries, the revenue, either you have multiple taxation, which is what Viscount Dilhorn thought would happen, or the revenue has to decide, will assess X, Y, and Z in certain proportions. And Lord Wilberforce said, well, as a practical matter, that can't be right, just to leave it to the revenue to decide who to assess in what proportion.
Not just as a practical matter, he says it's completely unconstitutional.
Well, precisely. The same point he said, first he described it as a practical issue, if the revenue can do all of this. And then he said, not only is it a practical issue, frightening, he described it, frightening practical issue, he said it's arbitrary, unjust, and unconstitutional. And those exact same points would apply if there were multiple transferors being liable. So it is possible that he was simply saying it's not a live issue. That's the view, to be fair, Mr. Justice Walton subsequently took. In my submission, what he's saying is there's no difficulty because as a matter of principle, one can't have multiple transferors. Either way, whether he's expressing that view or he's simply saying it's not a live issue, on either basis it doesn't actually help the revenue. If it's not decided, it's not decided, and one has to look at subsequent cases. So pausing there, we can see that his lordship was saying, based on the wording of the provision, it most naturally applies to persons who transfer assets abroad, to transferors. He then said at 1443, apart from linguistic considerations, there are other arguments, and he says, I mentioned 2. The first argument is although 739 is a penal provision, his lordship says, well, this cuts both ways, and the provision can't operate in an unduly extreme or unfair manner. And the interesting sentence to read out is at D, 1443D, but the argument turns the other way when so draconian a tax, astonishingly severe were Mr. Nolan's words, is sought to be imposed upon persons who had no hand in the transfer, who may never benefit from it, who cannot escape it, who remain under liability so long as they live or the settlement lasts. Now, the reason I flagged that sentence is because it's either my learned friends or the Court of Appeal's decision, but draws out the phrase, who had no hand in the transfer, and suggests, oh, well, if you had a hand in the transfer, you're therefore liable. With respect, that's a non sequitur. What Lord Wilberforce is saying is you can't have the Congreve situation where non-transferors are liable, because it means someone who has had no hand in the transfer can be liable. It doesn't follow from that any sort of a hand in the transfer suffices. You still have to work out the boundaries of what a transferor is. So I flagged that passage for that reason.
If I could just intervene for a moment.
Please, my lord.
I don't think you referred us to it, but page 1439, E to F, perhaps addresses the point that Earl Sales raised. What's focused on there is that the subsection, as it's put at E, the subsections give no guidance as to what's to be done if there's more than one individual to whom either subsection may apply. And then...
so could I ask which page you're looking at, my lord?
1439.
1443?
No, 1439.
Oh, apologies, 1439.
I'm sorry, I wasn't speaking loudly enough. So 1439 E to F.
Yes, my lord.
The problem is identified in general terms as one that arises where there is more than one individual to whom the relevant subsections might apply, rather than being specifically to do with trust beneficiaries.
Absolutely, that's quite right, my lord. So it was in the context of beneficiaries because that was the issue at hand, but the reasoning applies to both, and you're quite right, my lord. There are passages where it is framed in broad enough terms that it covers both. Thank you, my lord. So, in the passage I showed at 1443, that was the first point about the non sequitur, and actually one can see from the last sentence of that very passage, which is 1443E, it says to penalise is one thing, to visit the sins of the transferor on future generations is quite another. So another indication that Lord Wilberforce thought the section is limited to the transferor. The second factor then his lordship discusses is on the revenues interpretation, people who aren't seeking to avoid tax could be liable. So he says that's another factor in support of his interpretation. And then he says at 1443G, my lords, these and other arguments, together with the linguistic, persuade me that the better interpretation of the section is not that accepted in Congreve, but is one limiting its operation and charging effect to the transferors of assets. So once again, very clear that it's limited to transferors, that's the wording used. His lordship then proceeds to discuss, well, in light of that, should they actually overrule Congreve? So he thinks it's wrong, but should they actually depart from it, being former House of Lords authority? He ultimately concluded that that should be done, and there's just a couple of passages worth flagging. The first is at 1444D, where his lordship said that if the alternative was correct, so the alternative is correct, the alternative, which is supported by the language, is to suppose that the section was intended by Parliament as a limited section, attacking with penal consequences those who removed assets abroad so as to gain tax advantages. So there he's talking about the alternative being correct, the alternative to Congreve, and he's describing it as applying to those who removed assets abroad. So once again, you can see it's aimed at transferors, at 1444D. And in fact, at 1444E, it may be said, and I believe that some of your lordships share this opinion, that to limit the section so as to relate only to transferors of assets is to emasculate it, and he goes on to reject that. It doesn't emasculate it, but you can see he's limiting it only to transferors. And equally, over the page, and I'll give you the reference but without reading it, it's a lengthy passage, at 1445, E to G, there's a lengthy paragraph there where once again the language of transferors is used, to just one sentence. I find in the section, if directed at transferors and benefits taken by them, an ample and powerful anti-avoidance instrument. So his Lordship is using the word transferor. That was just above 1445G, that sentence.
But in this case, the contest was between people who were undoubtedly transferors and people who were simply the discretionary beneficiaries of the trust, who couldn't be described as transferors or even quasi-transferors.
That's quite right, my lady. And I take that point, but what his Lordship was doing was spelling out how, in his view, the section must operate, and one can see that from the fact that it's congreve, which says, well, it applies to anybody if you're individually, ordinarily resident in the UK. So that's the starting point. Congreve is it applies to that very, very broad corpus of individuals, and his Lordship is saying, well, if we're going to depart from that, what is the correct interpretation, and should I actually overrule existing House of Lords authority? So you're quite right, my lady. The context was beneficiaries, but I think the discussion was broader than that, the broader principle. And then the final conclusion by Lord Wilberforce was at 1446 at E. It is respect, I think, in respect for these and for the it is respect for these and the fabric of our fiscal law which persuade me that congreve, as to its principal ratio, and the following cases should be departed from or overruled, and the section interpreted as applying only where the person sought to be charged made or maybe was associated with the transfer. So the first point is it's the principal ratio in congreve that's gone, but the alternative line of analysis stands. The interesting point here is the or maybe was associated with the transfer. What does that mean? It's been suggested by my learned friends, well, if you're associated with the transfer, you're caught. I make two submissions on that. His Lordship may have meant one of two things by maybe was associated with. One possible interpretation is he's not answering the point. So, well, maybe if you're associated, you might be caught, maybe you're not, I'm not deciding that. I think that's unlikely. I think he was accepting that some sort of association with a transfer can be caught, and we can see that because he's just said in the same sentence, or the previous sentence, that the principal ratio of congreve is going, but the alternative implicitly therefore stands. The alternative was someone who's procured a transfer as opposed to having actually executed it himself. So it seems that by maybe, it's not Lord Wilberforce saying, I'm not deciding this, he's saying something different. What he's saying is, it may be the case that someone associated with a transferor is liable, but what it ultimately depends on is the type of association. So by maybe, it's not, I'm not deciding this, but it's maybe in the sense, well, he may be or he may not be. It depends on the circumstances. The question, of course, that then arises as well, what type of association suffices? And it seems to me the answer must be, in light of all the passages I've shown you yourselves, it must be someone who in reality is the transferor, because Lord Wilberforce has just said it applies, the section properly construed applies to persons who transfer assets abroad, or to transferors, he uses the word expressly, on numerous junctures. So reading this, the person who's made the transfer will be the person who's actually executed it, but you'll also have persons who don't actually execute it, but for one reason or another, looking at the matter in reality, you can say they are in reality the transferor, their level of association is sufficient to view them as a transferor, and they can be caught. But the important point is it's maybe, it's not it's not that any association, any sort of link, however tangential with a transfer, is enough for you to be liable. Now that was Lord Wilberforce, which I say is the majority decision. So I'll just flag a few passages for completeness from the other speeches, but none of those were the majority in the sense of having 3 or more people supporting them. Viscount Dilhorn, his lordship framed the point he was considering by reference to whether the individual sought to be charged had made a transfer of assets. So at 14...
Sorry, can I just ask, just before we move on, I noticed that at page 1446D, Lord Wilberforce is talking about the proprieties so eloquently stressed by Mr. Justice Walton in his judgments. Is he referring to Mr. Justice Walton's judgments in Vesti?
I believe so, because Pratt is the other big case with Mr. Justice Walton, but that came later.
Right. And can you just help us, where do we find that in the bundle?
So that is, it's at the start of this tab, I believe. And
the reason for raising it is I wonder whether there was a discussion in Mr. Justice Walton's judgment of some of these issues about multiple transferors.
So Mr. Justice Walton, I'll find you the page reference first, my lord. It, if I'm not mistaken, this tab starts at page 1416.
Right, thank you.
And I thought Mr. Justice Walton's decision was here, but it may be that I'm mistaken. I don't think it is. No, I don't think it's in the bundles, my lord. There is a description, quite a lengthy description of what Mr. Justice Walton held in the early few pages of Lord Wilberforce's decision. In a nutshell, the way Lord Wilberforce approached the matter was to note the argument that it's limited to transferors, but he said he couldn't, he was bound by Congreve, he was bound by the existing authority. So instead, his lordship, Mr. Justice Walton, addressed other possible arguments on the assumption that the section applied to non-transferors. So for example, with section 412 subsection 2, which I think was liability if you were in receipt of a capital sum, it was whether your liability could be limited to the amount of capital sum rather than the entire amount of income.
But at all events, I don't want to take up time on it, but since Lord Wilberforce does at least have very much in his mind Mr. Justice Walton's judgment, could that be supplied to us at some point?
He says judgments, and there are 2 of them. The citations are on page 1419, letter C. So perhaps those could be.
We could supply them to you.
Thank you.
And for what it's worth, although this is after the event, Mr. Justice Walton's reasoning comes out very clearly in Pratt, which we'll be going to. Obviously, there's a later decision, but it's possible his lordship changed his thinking, but one assumes he didn't. And from there, it can be seen very clearly that his lordship was against, for example, the concept of multiple transferors. But we'll certainly provide those 2 decisions, my lords, my lady. So Viscount Dilhorn framed the issue at page 1450. The respondents contended that these provisions only applied where the taxpayer assessed had made the transfer of assets. And his lordship noted, well, that had been rejected in Congreve. It was also the ratio of the Court of Appeal where the judgment of the court was given by Cohen. Both this House and the Court of Appeal clearly rejected the contention that the section only applied to the individual who had by himself or through an agent made such a transfer. And then he goes on to consider whether Congreve was right or wrong. So once again, his lordship was framing it in terms of whether Congreve was correct, or whether whether the taxpayers were correct in saying it should be limited to transferors. For your note, at page 1451, A to B, Viscount Dilhorn noted the 2 interpretations of such an individual. So either it's an individual ordinarily resident in the UK who sought to avoid liability to income tax by means of transfers of assets abroad, or the more expansive, but fewer words, it's just an ordinary resident individual in the UK. One point worth flagging is at 1451A, just so you have this for later. Having discussed the two alternatives, just next to B, His Lordship says, if that was their meaning, that being the longer form of words, then the scope of section 412 is limited. If, on the other hand, the words just mean an individual ordinarily resident in the UK, the decision in this case in Congreve was right. Lord Simmons, in the course of his speech, did not refer to subsection 8 of the section. It states inter alia, for the purpose of this section, a reference to an individual shall be deemed to include the wife or husband of the individual. These words have considerable significance and importance if such an individual means an individual ordinarily resident in the UK who is sought to avoid income tax by the transfer of assets abroad. If the decision in Congreve is right, it is not easy to attach significance to them. And the reason I flag that is that in a number of the speeches, one sees the argument being made that the spousal extension, I'll call it for simplicity, where an individual includes his or her spouse, only makes sense if the section was limited to transferors, not if it applies more broadly. I flagged that because my learned friends say, well, that wasn't a good point in law, and they use that to challenge Majesty. And when I come back to respond to their arguments, I'll show that that's wrong, and the spousal extension only makes sense if the section is limited to transferors, and Viscount Dilhorn and the other lords who refer to it were correct. But I flagged that, that's the passage in question. One passage worth flagging is for your note 1453b. His Lordship addressed the argument that the limited interpretation would leave a gap because, and now to quote, persons who transfer assets abroad may do so for the benefit of their families and not for their own benefit. So His Lordship is using the phrase persons who transfer assets abroad when describing the more limited interpretation which he ultimately upheld. And then His Lordship went on to decide that Congreve was wrong and ultimately should be overruled. But I say, although this speech isn't as detailed as Lord Wilberforce's, one can see from the way that the issue was framed by Viscount Dilhorn, and also by phrases such as this, where he's described the limited interpretation as applying to persons who transfer assets abroad, that His Lordship thought the limited interpretation which he upheld applies to transferors, or persons who transfer assets abroad. Lord Salmon, as I said, agreed with Lord Wilberforce. Lord Edmund Davies, once again for your note, at 1458G, His Lordship described the issue as being whether the section can apply to someone other than the individual who has made the transfer. So that's how His Lordship framed the issue. Once again, it was a shorter speech. His Lordship resolved that issue in favour of the taxpayers, so he disagreed that it could apply to someone other than the individual who made the transfer. That's to quote his words. So once again, His Lordship was directing it to transferors. And just for your note, 1464b is where His Lordship referred to the spousal extension, which I'll come back to. And then finally, Lord Keith, he agreed with Lord Wilberforce and Viscount Dilhorn. One passage worth noting is 1465, and it's by F. Describing the alternative in Congreve, His Lordship said the House also accepted an argument that in any event certain transfers had been organised or brought about by the taxpayer herself, but this ground, although capable of supporting the correctness of the actual decision on liability to tax, was plainly a subsidiary one. Now that phrase, organised or brought about, has been once again referred to, I think, either by the Court of Appeal or my learned friend as saying, Lord Keith was saying Section 739 applies to someone who's organised a transfer, whatever that scope of organisation is. That's not true. What His Lordship was doing here was describing in general terms what was done in Congreve, the alternative, but once we've seen the relevant passages in Congreve, we've seen the decision of Lord Wilberforce with which Lord Keith agrees, we can see that fundamentally it is someone who is a transferor who is liable. So if you've brought about a transfer, you'll be liable if in substance and reality you're a transferor. Organising, once again, it may be that someone who's organised a transfer can be liable. It depends what type of organisation it is and whether it's sufficient to view the person as a transferor. And the last point, once again, I won't turn it up, but for your note, at 1465 G to H is where the spousal extension is relied upon by Lord Keith. So that's the decision in Majesty, and we say it's very, very clear that it's limited to transferors. And that's been confirmed, importantly, in a number of subsequent cases. And here I'll read the relevant passages and give you the references rather than troubling you to turn to them. There's three authorities in particular. The first is Pratt, which was Mr. Justice Walton, and he said that the phrase "such an individual" is referring to, and now I quote, "a person who has sought to avoid liability to income tax by means of a transfer of assets, which, being reduced to its simplest element, means that the individual in question must, as the first step, be a transferor of assets," end quote. And that's page 1369. So it's also worth noting that when Mr. Justice Walton considered whether a person could be liable on the basis that he'd procured a transfer, and it was Mr. Justice Walton who described that as a quasi-transferor, he coined the phrase, his lordship stated that the question was whether, although the transfer was made by a company, I now quote, was the reality of the matter that somebody else was the real transferor, end quote. And that's page 1371. So once again, his lordship was viewing a procurer as someone who was the real transferor. The next case to note is Willoughby, which was an authority of the House of Lords, Lord Nolan giving the only speech. And he said at page 1382D, and I'll quote, "It has now been made clear by the decision of your Lordship's House in Majesty, reversing the first part of its decision in Congreve, that the charging provisions of the section can be applied only to the individual, or the wife or husband of the individual, who has made the relevant transfer of assets." So once again, House of Lords in Willoughby saying that the effect of Majesty is it's limited to the person who has made the transfer of assets. It's noteworthy, and we're not specifically taking you to Pepper and Hearst and so on, but at page 1383, Lord Nolan made the point that the position in Congreve was inconsistent with what the Financial Secretary to the Treasury had told the House of Commons when the 1936 Finance Bill was debated, namely that the transfer must have been made by the individual being assessed. I flagged that for interest.
Sorry, whereabouts on that page?
That was page 1383 F to G.
All right, thank you.
And his lordship gives the Hansard references there. And another point to note in relation to Willoughby is that Lord Nolan relied on the words in the preamble to hold that an individual must be ordinarily resident in the UK at the time of the transfer. And the reason that's relevant is the preamble, and I'll just read it so it's in our minds. I'll read the version in 739. It says, "Subject to 747, or B, the following provisions of this section shall have effect for the purpose of preventing the avoiding by individuals ordinarily resident in the UK of liability to income tax by means of transfers of assets by virtue of with," and it goes on to talk about income arising to a person abroad. Now, the reason I flagged that is the words which resulted in the House of Lords thinking that the section is limited to individuals ordinarily resident in the UK at the time of the transfer are in the preamble by individuals ordinarily resident in the UK. Equally, it's another part of the preamble, the by means of transfers of assets abroad, which has been relied on, for example, Mr. Justice Rotsley and Congreve focused in on those words in finding that you must be a transferor. So there's these various propositions which might come out of the preamble. It might also be said, based on the avoiding of liability words, that the purpose of the transfer has to have been to avoid liability to income tax. What's interesting is that Parliament has introduced subsection 1A, this was in the Finance Act 97 from memory, where they've removed those other two possible requirements, individual being ordinarily resident at the time of the transfer, purpose of the transfer being to avoid income tax. They've removed those, but there's been nothing to remove the requirement coming out of Vesti that based on by means of transfer of assets, you must be a transferor. So I flagged that as an additional factor supporting the decision in Vesti and that it remains good law.
So you say subsection 1, capital A, was introduced in 1997, replacing something. Where do we have the text that it was replacing?
I don't think it replaced anything.
Oh, so it was just added?
It was just added.
All right.
And the final case to draw to your attention is Magukian, which is also House of Lords authority. I think you were provided this separately, so it won't be in the bundle, but it will be numbered. And Lord Brown Wilkinson, with whom Lord Lloyd agreed, said at 3246E, and I quote, 5 conditions have to be satisfied in order for section 478.
Could you give us the page, the 3246,
my lord.
3246, right.
But it won't be in the main bundle.
It's page 5 of the supplementary bundle.
Yes, my lord, I think that sounds right.
Thank you.
And it says that E, 5 conditions have to be satisfied in order for section 478, which was another predecessor to 739, to apply. 1, the taxpayer or his or her spouse has made a transfer of assets by virtue of which income becomes payable to a person resident outside the UK. So once again, that wasn't the central issue in the case. So you've only got Lord Brown Wilkinson flagging it, and Lord Lloyd agreed at 3249F. But you can see once again reference back to the section being limited to transferors. So some are proposing there, we say it's clear from Vesti and from the subsequent cases that it's a transferor that must be liable, persons who transfer assets abroad. Someone who doesn't execute the transfer, him or herself, may be liable, but if in substance and reality one can view that person as the transferor. And we've seen from Congreve, and equally from the passage in Pratt, which I drew to your attention, where Mr. Justice Walton used the phrase real transferor, in both Congreve and Pratt, someone who procures a transfer was viewed as someone who in reality is making the transfer. And it's worth noting at this juncture that in consequence of Vesti, Parliament introduced section 740, which is, in fact, it's expressly headed, it's a tax charge on non-transferors. And the reason I flagged that is, rather than the relevant wording in section 739 being changed in a way to move away from what was held in Vesti, to extend it to someone who's not a transferor, instead, Parliament went down a different route, which was to introduce a specific charge on non-transferors, which suggests that the scope of 739 remains as it was. Now, at this juncture, I'll pick up points.
You don't say that countermands, as it were, your acceptance that someone who is in reality a transferor will still be caught
Not at all.
739.
That's still good law, because you are still a transferor. Quite right, my lady. Now, at this juncture, I'll pick up some points made by HMRC and by the Court of Appeal to do with Vesti. As a starting point, my learned friend says at paragraph 34 of his case that our argument is premised on the assumption that one is seeking to identify the individual who has made the transfer, and they say there's no support for that. But the simple answer is, when they say who has made the transfer, to be clear, we're not limiting it to the person who's actually executed the transfer. It's someone who in reality is a transferor, as Lady Rose just asked me. And second, when they say there's no support for it, well, with respect, I mean, Vesti and the wording of 739 is the support. Now, the revenue's fundamental argument, and we can see this at paragraphs 13 to 19, so there's quite a lot on it. They say that based on Vesti, there's a requirement that a person has, to quote, had an involvement, end quote, with the transfer. It is said that this involvement can take a range of forms, and the House of Lords Investi did not define which individuals could be charged under 739, and the Revenue then says being associated with or acquiescing in a transfer suffices. Well, I say, my lords, my lady, in light of the passages in Vesti and the submissions I've been making, it's clear that the Revenue's description of Vesti is wrong. For a start, the House of Lords Investi did not use the terminology of being involved with or had an involvement with a transfer. That terminology just didn't come up. What they did say very clearly is that it's the person who's the transferor who must be liable. And so far as this point about being associated with or acquiescing in a transfer is concerned, associated with I've already dealt with. Certain types of association will count, others won't. Acquiescing, the first point is there's nothing in Vesti which says acquiescing in a transfer suffices. That it just didn't crop up. It's not discussed in Vesti. The second point is, and this ties in with Anne, who we'll be coming back to in terms of the additional reason, but as a matter of principle, I say it's very difficult to see someone who just does nothing can be said to be a transferor. I'll develop it again later on. But to respond to their point that an acquiescer suffices, we say, well, someone who just acquiesces isn't a transferor. Now, the Court of Appeal's analysis was at paragraphs 60 to 65. They discuss whether a quasi-transferor can be caught by 739, that's 60 to 65 paragraphs. And then at 66 onwards, they discuss whether there can be multiple quasi-transferors, which is something I'll return to in a moment.
Paragraph 60 to 65.
Quite right, my lady, paragraphs. And it's page, in the key bundle, it starts at 130. Now, so far as, well, those first paragraphs, 60 to 65, the key point made by the Court of Appeal, which comes out most clearly at 61, and I quote, is that, quote, Vesti does not establish that someone need have been a transferor in a strict sense, end quote, for 739 to apply. And then the Court of Appeal went on to say that it's sufficient for someone to procure a transfer. Now, it seems that by strict sense, what Lord Justice Newey meant was that you don't need to actually execute a transfer to be liable, and we agree with that. You don't need to actually execute it, but nevertheless, I must make a few comments about the reasoning in these paragraphs, because ultimately the Court of Appeal took a very broad view of who can be liable under 739, and the foundation of that broad view was the analysis in these paragraphs. So the first point to flag, it's a small one, but it said at paragraph 60 that the need for an individual to be involved, and at this juncture they're not discussing the level of involvement, but they say the need to be involved is not express. Maybe that nothing turns on this. The Revenue makes the same point, that there's no express requirement. For completeness, we say that the legislation does contain an express requirement to be a transferor because of the words by means of transfers of assets. It may be that nothing turns on that, but we do say it's express. The key point at 61, Lord Justice Newey acknowledged that Lord Wilberforce spoke of liability being limited to the transferors of assets, so that's been acknowledged. But then Lord Justice Newey said, well, counsel for taxpayers in Vesti had described transferor as the person who made or engineered or having power to stop it allowed the transfer. But with respect, there's nothing in Vesti, which we've looked at the key passages, which suggests that Lord Wilberforce was adopting that broad or expansive meaning of what constitutes a transferor. And it's noteworthy that paragraph 71, which is page 134, Lord Justice Newey himself considers that passively allowing the transfer is insufficient. So I flag it once again.
The numbers of the pages in the...
These are in the key bundle.
In the key bundle.
Page 134 of the key bundle was paragraph 71, my lady. The next point, also at paragraph 61, Lord Justice Newey noted that Lord Wilberforce said 739 can apply if an individual has made or maybe been associated with a transfer. I've already made my submissions on that, and it doesn't lead to an extended view that any sort of association suffices. fourth point I make about the Court of Appeal's analysis in these paragraphs 60 to 65 is that there's a lot of focus on the fact that a person can be liable if he procures a transfer. And we agree with that, but we note, by way of observation, because this may be what led the Court of Appeal to difficulty later in its decision, is that it failed to draw out clearly in its analysis the fact that although a procurer can be liable, it is because he or she is in substance or in reality the transferor, and that doesn't come out. It's almost viewed as transferors and procurers, but they're not mutually exclusive categories. They are one and the same. And a final point worth noting, this is almost for completeness, but Lord Justice Newey says at paragraph 65, which is 132 in the key bundle, he says it's inappropriate to talk in terms of procure being a gloss on the basis that even the word transferor does not appear in 739, and that itself might be said to be a gloss. Maybe ultimately nothing turns on this, but procure clearly is a gloss. That word doesn't appear there at all. And you can't naturally interpret any of the words. For example, by means of transfer or transfer doesn't automatically or most naturally mean procure. It most naturally means a transferor. So I say procure is a gloss. Arguably, the word transferor isn't a gloss because it's just the natural interpretation of the words there by means of a transfer, by means of transfers of assets. But in any case, whether these are glosses or not, the fundamental point is, based on the wording of the statute and a range of other factors, the House of Lords held that the provision applies to transferors, and that's what one is concerned with. So following on from that, the question then arises, well, can a minority shareholder be a transferor? And starting with, this is the second proposition, which is relatively short, the third one will be longer. As we've seen, as Mr. Justice Walton said in Pratt, when you're looking at a procurer, the question is whether, although the assets were transferred by a company, can it be said that the individual is the real transferor? That's the question one's looking at. And in our submission, that cannot be the case in relation to a minority shareholder. We say that if you're a minority shareholder, you might vote in favour of a transfer, but you yourself cannot bring about or procure the transfer, and so you cannot be viewed as being the real transferor. As Lord Justice Phillips said at paragraph 145, which is page 158 of the key bundle, he said a minority shareholder does not procure a transfer any more than a single voter procures a change of government. And there are certain additional factors to keep in mind when we say that a minority shareholder just cannot be a transferor as a matter of principle. The first is to keep in mind the separate legal personality of the company, and as per Prest or Presht and Petrodel, and the relevant page for your notice 2287 to 8, paragraphs 34 to 35, Lord Sumption from memory, the circumstances, as we all know, in which the corporate veil can be pierced are limited. And the reason I flagged it is if you've got a company with an individual who's controlling it, you can see that in reality that person might be said to be the transferor. But if one extends it to minority shareholders, which isn't then just 3 minority or 5 minority, it could be 100 minority shareholders, 600 minority shareholders, it gets, as a matter of principle, difficult to see that that person has procured anything, but also if one starts essentially equating the activities of the company with a broad range of minority shareholders, that, in our submission, comes close to, or if not, in fact, does impinge upon the separate personality of the company. And it's important to remember in this respect, the legislation is explicit. It applies to individuals. And one has to keep that in mind. It doesn't apply to companies, it applies to individuals. There might be certain circumstances where one can say something done by the company is in reality done by the individual, but one has to keep in mind that fundamentally it is related to individuals. The other 2 points worth keeping in mind in relation to this argument in principle is that the second point is one has to remember that the fact that you're a minority shareholder doesn't mean that you suddenly escape any liability. Section 740 still exists, and to be fair, with respect, it's the more sensible charge. It's the charge on the benefits received, as opposed to the entire income of the transferee. But it's not the case that if you're not a transferor, somehow you get out because you're a minority shareholder. There's still 740 there, which will tax minority shareholders who receive benefits. And as I alluded to earlier, that the fact remains that just as Parliament hasn't done anything to remove the transferor requirement, equally, in light of the cases, in light of cases such as Pratt, it could, if it had wanted, made it absolutely clear that minority shareholders are caught, or multiple transferors can be caught, but it's never taken the opportunity to do that. So we say, in principle, a minority shareholder can't be caught, and we say that's reinforced by the fact that a number of problems could arise if minority shareholders can be liable. And these were identified, or two of these three in particular were identified by Mr. Justice Walton in Pratt. It's worth noting at the outset that the Revenue says that our case, or our argument against multiple transferors, is based purely on these three difficulties. It's not. The starting point is the wording of the legislation, and I say in principle the minority shareholder can't procure something, but we say that these points reinforce the position. The first point is that if there can be multiple transferors of the same asset, then multiple individuals can be made liable in relation to the same income. And that was a point identified by Mr. Justice Walton in Pratt, who said it would be arbitrary, unjust, and unconstitutional for multiple transferors to be liable in relation to the same income. That's page 1371 to 2 of the bundle, main bundle. Now it said, well, now you have section 744, which provides apportionment machinery, and therefore this ceases to be a problem. And we say, well, that's not right for two reasons. The first is, it's not clear that section 744, which provides for apportionment, was catered to deal with was introduced, to deal with the circumstance of multiple transferors. And the reason I say that is, your starting point, pre-744, is that multiple transferors aren't caught. That's Pratt. It's said that 744 has changed the position, but if 744 wasn't introduced in that context or for that reason, it casts doubt on the argument that this is what 744 achieves. And the reason I say 744 wasn't introduced to deal with multiple transferors is that it was introduced in the Finance Act 1981 alongside what became section 740. So you had Majesty, which says discretionary beneficiary.
Which Finance Act, sorry?
1981. Got that right? Yeah, 1981. And it was sections 45 and 46 from memory, my lady. You've got Majesty, which says discretionary beneficiaries can't be liable under under 739. In response, there are two provisions introduced side by side. What became 740 and what became 744. 740 means that beneficiaries can be taxed who aren't transferors, and 744 provides for apportionment. Most naturally, therefore, the reason it was introduced was partly because you might have more than one beneficiary caught under 740, and partly because you might have a transferor under 739 and a beneficiary under 740, so once again there can be apportionment. There's nothing to suggest that the reason for its introduction was to cater for multiple transferors. So that's the first point. The second point is that in any event...
Sorry, can you just remind us of the date of Pratt?
Pratt was, my lord... Pratt was 1982, and before you know it, its bundle, main bundle, it starts at page 1321. The second point is that in any event, section 744 cannot have extended the scope of the charging provision. Prior to the introduction of 744, the position, as I say, was that multiple transferors could not be liable. And we say that 744 couldn't have changed that. Now, Lord Justice Newey said in paragraph 69, which is in the key bundle at page 133, he said that even if the absence of apportionment machinery prevented Section 412 applying to multiple transferors, that's the predecessor section, that obstacle was removed, and it was never a difficulty under ICTA 1988, which always contained 744. And his lordship makes the same point at paragraph 71, which was also page 133. We say that's wrong. The first point is we say that the introduction of 744 cannot have extended the scope of the charging provision, i.e. 739. 744 is a provision which relieves against unfairness which otherwise might arise, but it doesn't result in that unfairness arising in the first place. It can't do that. So just as a tax liability couldn't be extended to non-transferors by 744 alone, and instead Section 740 was needed to extend the scope of tax liability, equally we say that 739 couldn't be extended to multiple transferors by 744 alone. You would have needed some change in the legislation. And I won't turn this up, but for your note, at page 3128, this is Bennion, which quotes a case called Boss Holdings as saying Parliament cannot have intended the meaning of a subsection to change as a result of amendments to other provisions of the same statute, and it's the same sort of point we rely on here. So we say it can't have extended the scope of the charging provision. And second, this notion that it's material, that 744 was in ICTA from the outset, is...
Could I get the reference that you just gave us?
The Bennion reference, yes, my lord. It's at page 3128.
3128.
And the second point I was about to make was the fact that 744 was included in ICTA from the outset of ICTA 1988 is frankly irrelevant. To put it this way, if the fact that 744 was included in ICTA from the outset is to have any relevance, it must mean that under the previous legislation, which was ICTA 1970, into which 744 was introduced, or the predecessor was introduced, it must be the case that under that predecessor legislation, multiple transferors couldn't be liable because 744 wasn't there from the outset, but under ICTA 1988 they can be liable because it was there from the outset. And I said, well, that frankly has to be wrong, because ICTA 1988 was what we refer to as a tax law rewrite, or more technically, the wording at the start of this ICTA is that it was a consolidating statute that appears right at the front of ICTA. And in that respect, the page reference is 3135, and Bennion notes at 3135 there's a presumption that consolidation is not intended to change the law. And at 3138, it said this applies equally to tax law rewrites as it does to non-tax consolidations. Now, the revenue in relation to 744 makes two arguments. So that was the Court of Appeal's arguments, which I've dealt with. The revenue makes 2 points. One point is this point about 744 always having been in ICTA, and this is paragraphs 39 to 41 of their case. The point about 744 always being in ICTA I've dealt with. The other point is they say that 744 permits the apportionment of less than 100% of the income of the person abroad. So in this case, for example, if all three were liable, Stephen, Anne and Peter, I think it would be about 76%. And they say, well, you're allowed to do that under 744. Well, we don't dispute that, but we're not relying on, I mean, it's just not an answer to our contentions. We're not saying 744 has to apply to 100% of the income, it can't apply to 76%. That's just not our argument. The argument is as I've presented it, so it's something of a red herring by the revenue to make that point. The second practical difficulty we say which arises is to do with the motive defence. And the reason it's a difficulty is that it doesn't apply separately to each individual transferor. And the issue is this. To be clear, we're not saying, because it's put against us by the revenue and also by the Court of Appeal, but look, there are other circumstances where companies make transfers of assets, where the legislation requires you to work out the purpose, where a company has done something and the purpose can be worked out. We don't dispute that. We're not saying you can't work out a purpose of a transfer when it's done by a company with multiple transferors. What we're saying is that 739 is a penal provision with far-reaching consequences, And the motive defence is the only source of protection against that. And if multiple transferors can be liable, then it's possible for an innocent transferor, so an individual who doesn't have a tax avoidance motive, to be liable. So against that background, dealing with what the Court of Appeal said, one argument was, well, it's not uncommon for tax legislation to apply where company purpose needs to be determined. Well, I say that's not our argument. In terms of what actually is our argument, Lord Justice Newey, this is at paragraph 70, page 133 of the key bundle, he acknowledged that if there are multiple transferors, then a particular one may be unable to rely on the defence because the overall purpose was tax avoidance, even though he had no such purpose himself. But his lordship said, well, such cases will be rare. With respect to the Court of Appeal, that's not a good answer. The first point I say, it's unclear, perhaps unlikely, that such cases will be rare, because if you can have multiple transferors, the scope of this becomes extremely wide, especially if you accept the revenue's position that it's multiple transferors, including acquiescers. I mean, then it could be thousands and thousands of shareholders.
Isn't the difference here that they were all directors of the company as well?
They were directors of the company, but the point I'm making, my lady, is one of principle, which is even if you are all directors, in fact, you might have, whether it's 3 or 5 or however many individuals being liable, and the same principle could apply if you're not a director, which is you might have the overall purpose of the transfer being tax avoidance. So anyone who is then a transferor gets caught, even though a particular individual isn't. And a good example actually on directors was given by the upper tribunal, and they said, well, you might have a director who's a minority shareholder. He votes in favour of a transaction, so he's a procurer, but he's on this analysis where minority shareholders are caught. But the reason he votes in favour of it isn't because he has a tax avoidance desire himself, but his duties as a director require him to vote for what's in the company's best interest. So he has no tax avoidance purpose, but because overall there's a purpose, he gets caught. And that, we say, that problem doesn't arise if you can only have the single individual being liable, the single transferor. It's when you open it up to multiple transferors, you can have people...
Yes, but your point, well, there could be hundreds, there could be thousands of minority shareholders.
Yes.
It's not what they're actually talking about here, because if you're right that the test is, are they in reality, then the fact that are they in reality the transferors, then you have to look at the reality, which is that this was a small family company in which the shareholders were also the directors of the company.
There's two answers to that. So the first is, if it's not limited to what I say is in reality is the transferor, which would then be actually none of these individuals, in fact, on my case, none of them are in reality transferors. But if it's not in some way limited, it could be very wide. And my point was that Lord Justice, on Lord Justice Newey's approach, he didn't even consider the possible breadth of it. But even if it is narrow, so even if his lordship was right that it's rare cases, even in those rare cases, it will be an unfairness for the individual who, for example, Anne in this case, who there's a finding of fact, she had no motive. I know Mr. Baker will come back to this, but that's an example. She had no motive at all, but you get stung by a penal provision which says you ad infinitum, so long as income keeps arising and you're alive with the power to enjoy, you're going to be taxed on the entirety or an apportioned part, if 744 can apply, of the income. And we say it's that unfairness which was identified by Mr. Justice Proch. My learning is quite right. Peter had resigned as a director before the transfer. He'd resigned in July '99. So there's this point about the unfairness, which was one of the factors relied upon also by Mr. Justice Walton in Pratt. And we say that's another reason why multiple transfers shouldn't be possible as a matter of principle.
So is Peter's status as a quasi-transferor dependent on his shareholding?
And I think it's accepted, I assume it's accepted by the revenue, that if you're a director with no shareholding, then you can't be liable, you haven't procured anything, you don't have any sort of interest indirectly, as it were, or through company ownership in the underlying assets. Now, HMRC, that's the Court of Appeal's point. HMRC, it makes the point, well, there's other circumstances where you discern a company purpose, and I say that's not our argument. They also say, oh, well, look, you can have multiple transferors in other contexts, so ignore a company, they say. Let's say you've got shares or you've got a parcel of land, and you can have multiple transferors of those assets, and they say, well, doesn't the same problem arise there in relation to the motive defence? That's at paragraph 38 of their case, and my answer to that is no, it doesn't arise there, because if you've got something like land or shares and it's multiple owners, then actually you have multiple transfers. Each individual will be transferring his or her own beneficial interest. Each one will be a separate transfer, and the motive defence will be applied separately to each of them. And the final practical difficulties, the third one, is I say that if multiple transferors can be liable, then there is difficulty in drawing the line as to the scope of 739, and there's two aspects to that contention. The first is that very literally it's difficult to draw a line, because if it's limited to a single controlling shareholder, one can quite clearly see where the dividing line is. But if you can have someone who doesn't have a controlling interest, but can nonetheless be liable, it's very difficult to see where that line is drawn.
When you say a controlling interest, what do you mean by that?
So you can control more than 50%.
And you're looking only at a technical controlling?
Technically, yeah, more than 50% yourself or through a proxy, so you can control more than 50%. And I say, well, where do you draw the line? So unless every single shareholder is caught, then it's clear what the line is. It's every shareholder. But if it's not that, and it's not our case, it gets very difficult. So we say, for example, if there are 3 equal shareholders, they're all in favour of a transfer, but at the meeting the third one abstains because he says, well, the first 2 have voted in favour of it, I just don't need to vote, I'll stay silent. Is he in reality a transferor? Or what if you go one stage further? If he knew in advance that the other 2 were going to vote in favour, what if he says, well, I just won't turn up to the meeting, I don't even need to be there? So I say, one, where is the line? And on that point, the revenue says, well, Parliament deliberately hasn't delineated the line because it's a broad spectrum anti-avoidance provision, and so they don't want individuals to know whether you're within it or without it. And I say, well, frankly, that's a startling submission. Yes, it's an anti-avoidance provision, it's penal. If anything, that cuts both ways, as was said by Lord Wilberforce in Majesty. But although it can be fact-sensitive, so in a given case there might be a dispute as to whatever the boundary is, whether you're on the right side or the wrong side of that boundary, there has to be an articulated boundary. Parliament can't have intended, well, just the boundary is unknown. It might be that it's difficult in a given case, but there's got to be some governing principle. It can't be left to the individual just to not know where is the line. Is it someone who abstains is caught? Is it someone who doesn't turn up? There's got to be something which an individual can use as a touchstone to work out if they think they're going to be liable or not. And then the second point, so one was the difficulty in the line, and the other aspect of this submission is the point about the breadth, which I've already made essentially. But if, certainly if HMRC is correct, passive role suffices, acquiescing suffices, minority shareholding suffices, it becomes extremely broad. And this was the point made by Lord Justice Phillips in his dissent. One has to recognise that it's a penal provision with far-reaching consequences. As I said earlier, if it essentially can apply to any shareholder, as it would on the revenues case, well, then that emasculates the limitation of the provision to individuals. And at this juncture, it's worth perhaps making a couple of comments on a point which was put by the Court of Appeal, the majority decision, to my learned senior. They said, well, what if you've got just a 50-50 company? And Lord Justice Newey considered it unfair that in that circumstance, both brothers, I think he gave an example of brothers, wouldn't be liable. And my answer to that, I learned seen dealt with it below, but just to deal with it again, is with any principle of law where you've got a boundary, if you're just over the edge of it, that's going to seem like prima facie the most unfair case. It's like with a limitation period. If you're 1 day over, that seems harsh. If you're 10 years over, you say, well, it's 10 years. There's no unfairness there. And it's the same point. So the 50-50 is the most extreme example that one could come up with, I think. But we say that the principles remain exactly the same. If you've got less than a majority, so you're right on the cusp, you can't procure the transfer yourself. You have the same problems with the motive defence, you have the same problems with the apportionment machinery, the same points apply. And as Lord Justice Phillips said at paragraph 146, which is at page 159 of the key bundle, his lordship said, well, most, if not all, of the decisions, and this was dealing with this point about the 50-50, he said that most, if not all, of the decisions of a company will be taken with the underlying support of shareholders who collectively hold a controlling interest. And he said, if being part of a group of minority shareholders that vote in favour of a transaction is sufficient to be liable, then that must apply, his lordship said, not only to the two 50-50 brothers that Lord Justice Newey had mentioned, but also to thousands of shareholders in a PLC. And Lord Justice Phillips said, well, that can't be right.
It occurs to me, just apropos of that, to wonder what about the shareholder, say a shareholder director who votes against? In a way that this is, it's a more interesting case than Anne's, I think. Just imagine Anne was an active director, and she voted against this transfer. The transfer would still take place. It would still have the consequences it had. The motive for the transfer would be the same as it was.
Yeah.
Is the director and shareholder who votes against caught by these provisions?
Well, absolutely, my lord. I mean, that's
Mr. Ewart as well.
Yeah, I mean, we would of course say no, most definitely shouldn't be. But you can, and I'm sure Mr. Ewart will do a better job. But he'll come up with some argument, I'm sure, in response to that as to, well, maybe they accept that such a person can't be caught. But if that were the case, then it almost seems like a very easy. The abstainer isn't caught. Possibly, we don't know what would happen if we have this broader principle that the revenue advocates. But let's say, for example, an abstainer isn't caught because they haven't actively transferred it, and that's accepted. But what if you then, I should take the other way around. If the abstainer is caught, or someone who plays a passive role is caught, because the revenue certainly argues that, they say a passive role is caught. So take Anne. Passive role is caught on their case. What if she deliberately votes against, knowing that it's going to go through anyway because of the other votes, as a tool to get out of this? It's these very fine, nebulous points start arising, as you point to, my lord, which simply don't arise on our case.
Yeah. Well, the point is, it's really just elaborating your point that if you have multiple transferors, it's difficult to attribute motive to particular individuals.
Absolutely.
You might have an individual whose motivation was clearly, whose wishes were clearly at odds with the objective motive of a transfer.
And still gets caught. Quite right. The last 2 points for me to address, which will be quicker, are the additional point in relation to Anne, and then I'll make some comments right at the end on the ongoing validity of vesting. So we say, well, the Court of Appeal said at paragraph 73, which is 134 of the key bundle, and we agree, they say that in any event, Anne should not be liable because she didn't do anything. They refer to various findings by the FTT. Paragraph 21, the FTT said Anne had virtually nothing to do with the business after 1990.
She was a director.
She was a director.
So why did she do nothing in relation to the business?
I think the reason she did nothing, I think it says in the first day decision, my lady, that she was essentially responsible for family duties. So she was a director, but it was Stephen and Peter
Did she draw a salary as a director or make any drawdowns from the...
I'll ask.
Well, sure. Regardless of whether she did, she was a director and she owed duties to the company, presumably, as a director.
She will have done, my lady, but it's on this particular, it's the totality of these factors that, well, she had the three factors, and then I'll draw it in to answer your question, where she had virtually nothing to do with the business, they said, after 96. She played no active part in the decision making, that's at paragraph 337, this is the FTT, and they say she did not have a motive, that's paragraph 516. And the Court of Appeal said, well, in light of that, she didn't procure anything, and that's our submission, or why we agree with it. Fundamentally, even if one can have multiple transferors, that still doesn't detract from the starting point in Majesty that you have to be a transferor. And we say that
you say she did nothing, but nonetheless, the existence of her shareholding means that the others weren't the controlling shareholders.
I didn't catch the last part of that, so.
The existence of her shareholding may mean that the other two were not controlling shareholders.
Quite right. The other two held 50% between them.
Yes.
Now, but it's an interesting point, actually, I think, my lady, which I was pondering this the other day, but we don't make this further submission. But when one thinks it through logically, one can see we're starting from the proposition that you can have more than one transferor, which we say is wrong, but let's assume that's right. And we say, for the reasons the Court of Appeal gave, Anne shouldn't be included, so she's not a transferor. So that then leaves two transferors, Stephen and Peter, who between them had 50%, and it was Mr. Justice Walton in Pratt, who is in the alternative, having set out all the points I gave as to why you can't have a multiple transferor, his alternative was, well, in any event, in that case, it was 3 out of 8, I think, who held 29% of the rights. And he said, well, they don't even collectively have a majority. And so I was pondering whether one could go one step further and say, if Anne is knocked out, automatically Stephen and Peter must also be knocked out, because then you're left with 50% rather than 76. But I think the view I've got on that is, if we're accepting against us that you can have minority shareholders being caught, then we would accept that you don't need a group of those minority shareholders with greater than 50%, if on the facts one can say those minority shareholders were the transferors. So we don't make that further proposition that without her shares it was only 50% and therefore they both fall out at this stage as well. If you consider that minority shareholders can be caught, we accept that in principle then Stephen and Peter would be liable, but it was Anne who would get out simply because she didn't do anything. So it's just going back, stepping back and looking at the company that's made the transfer. We're saying that it's an individual that must be liable under 739. What is it that this individual has done to mean that although she didn't actually make the transfer, you can nonetheless say in reality she was the transferor, and we say, well, she did nothing.
But if you had two people, shareholders, one with 49% of the shares who was actively engaged in the business, and one with 51% who was like Anne and didn't do anything about the business, then are you saying that the one who has the majority but doesn't do anything in the business gets out because they weren't the transferor, but the other one with the 49% also then gets out because they're only a minority shareholder?
Well, on our case, the minority shareholder wouldn't be caught. At this stage in the argument...
Would be caught.
Would not be caught. We say minority shareholder can't be caught, but at this stage in the argument where we're considering the alternative in relation to Anne, we're assuming we've lost on the earlier points. So the 49% individual could be caught as a transferor in this at this stage in the argument. Our primary submission, of course, is he shouldn't be. But either way, the 51% wouldn't be caught because he hasn't done anything in your example, my ladyship. But the important thing is it's not them getting out, to use your phrase, because there's section 740 there. So they're not, in some abstract sense, getting out of liability and sort of getting away with it, as it were. There is section 740, and to the extent they receive benefits, they will be liable to tax.
And that would be both of them?
That would, if they're not transferors, quite. Now, the revenue, a large chunk of the revenue submission, some 4 or 5 pages, paragraphs 22 to 33, deal with Anne. It seems to be the majority of their submissions, in fact. And there's 2 lines of attacks that they advance, and I'll briefly comment on both. The first is, it's under the heading, procuring a transfer is not a necessary condition for the application of 739. And that section of their case is paragraphs 23 to 30. And essentially what they say in that passage, their primary submission is that active procurement is not necessary for 739 to apply. A passive role can suffice. They say the reason previous case law has not accepted a passive role was because of an inability to apportion, and that 744 resolves this. But with respect, I say that reasoning is fundamentally flawed as a matter of logic. As a matter of logic, the absence of an ability to apportion might be relevant to whether you can have multiple transferors or only one transferor being liable. As a matter of logic, it's got nothing to do with how active or passive a role is sufficient to qualify as a transferor. So as a matter of logic, it's just wrong. And unsurprisingly, in the existing cases, where the absence of an ability to apportion has been relied upon, it has been in relation to the question of multiple versus single, not in relation to degree of activity. So in Majesty, it was relied on to stop multiple discretionary beneficiaries being liable. In Pratt, it was relied on to stop multiple transferors being liable. But of course, at this juncture of the argument, we've already accepted multiple transferors can be liable. We've lost on ex hypothesis on the earlier point. We're dealing on the additional or alternative reason relating to Anne. We're assuming you can have multiple transferors. So at this juncture, with respect, 744 is a red herring. Second point the revenue makes at paragraph 28 is that passive role should suffice because it's a broad spectrum anti-avoidance provision, whereas Lord Wilberforce said that cuts both ways, and equally it mustn't be too broad. HMRC says that there would be unfortunate consequences if 739 was restricted to someone taking an active role, and they essentially give examples. They say that you could engineer things to dissociate yourself from a transfer, or you might, if there's 3 brothers, 2 of them might take the decision and one of them leaves it to the other. They give these types of examples. The simple point is, well, same response I gave to my lady, you don't get out in those circumstances. They will still be caught under 740 in those examples. And the second point is, fundamentally, the requirement in the legislation is, as held in Majesty, you must have made the transfer. You must, in reality, be the transferor. And if, as a matter of principle, that doesn't include a passive role, well, then these examples go nowhere, especially because, as I say, 740 is there in the background. Their final point to do with this is they say, well, if a passive role is excluded, 739 would depend on fine distinctions. Well, that goes nowhere, because if a passive role is excluded, then yes, there will be cases at the boundary where there will be a debate as to whether someone has been active or not. But equally, unless they're saying every shareholder is caught, there'll be debates about passive role versus something that's still not enough to even satisfy that. The example given by Lord Reid of someone who votes against something. Well, how does that fit in with a passive role sufficing? So it's not that our case gives rise to arguments and theirs doesn't. And the final point they make in this respect, under this heading, is to say, well, even on our case, they say if you're a 55% shareholder, you could be liable on 100% of the income, because 744 only allows apportionment if there's more than one person who could be caught. And our response to that is, as a starting point, it's got no relevance to whether a passive role or an active role is needed, the fact that a 55% shareholder could be liable on 100%. Second, we say, well, the same thing could happen under their case. Even if a passive role suffices, on their case, you can have a circumstance where you have one shareholder who doesn't have 100%, who is liable on the whole income because 744 doesn't apply if there's only one person. So it's neutral as between both of us, that factor. Third point is, for completeness, if you do have a 55% shareholder, it's unlikely he's going to be liable on 100%. May happen, but one has to remember that the other 45%, if they receive benefits, they'll be taxed under 740, and then 744 will apply, and the transferor won't be taxed on 100% because there'll be an apportionment between the transferor and the non-transferor. And finally, the fact that in principle, although it's irrelevant to the passive versus active argument, but the fact that in principle a 55% shareholder could be liable on 100%, all that shows, and 744 doesn't apply in that circumstance in principle, you can have that. All that shows is that 744 is not the panacea that HMRC suggests, dealing with each and every point that sort of arises. The other line of challenge advanced by the revenue in relation to Anne. So the first is passive role suffices. The second is they say in any event she had an active role. They have that at paragraphs 31 to 33 of their case. We say, well, that's the 3 points they rely on go nowhere. One is they say that the FTT found that she was happy to go along with the decisions of Stephen and Peter. But we say, A, that in and of itself is a passive role, and B, you've then got all the other things found by the FTT, which the Court of Appeal drew attention to. And then they say, well, she played an active role because she took shares in the Gibraltar company, and she was at the EGM, I think it was, where the capital of or the number of shares in the Gibraltar company was increased. You say, well, so what? That's got nothing to do with her being a transferor of an asset by SJA, the UK company. The fact that she's a shareholder in the transferee doesn't make her a transferor in relation to the UK company. Doesn't mean that she played an active role in relation to the UK company. And so the final point they make on this, they say is, at paragraph 32, they say that Anne took an active decision to approve the transfer of the business, and the fact that she didn't sign the transfer agreement is irrelevant. Well, A, she didn't take an active decision to transfer the business, and so far as her not signing the transfer agreement is concerned, well, we don't rely on that. Maybe noted Stephen didn't sign it either. Or more actually, he signed it, but for the Gibraltar company.
What do you mean by an active decision?
Well, I suppose it's for the revenue says she did take an active decision. We say that an active decision, even if you're taking a minority shareholder, can suffice. Even if that suffices, it's fundamentally someone who votes in favour of the transaction.
At the moment, I'm not finding this at all clear. Where the transferor is strictly speaking a company, the decision will be taken by whatever is the relevant decision-making organ of the company, and depending on the circumstances, that could be a number of different organs, but usually it would be the board of directors. So the board of directors takes the decision. Individual directors may be voting one way or another. They may be on the golf course. They may be in the hospital. There are a multitude of possible circumstances. And it strikes me at the moment as rather odd to be trying to undertake the exercise that we're discussing, even at the level of directors, before you start going to shareholders who are not directors.
I entirely agree, my lord. And these problems are, or a spotlight is drawn on them if you can have multiple shareholders being liable, because then, as you say, you have all of these different permutations that one needs to address. One could, in theory, go to an extreme and say, well, actually, you can never have an individual being liable when a transfer is made by a company, because the legislation says transfer by an individual. That would be the extreme. We haven't gone that far in our submissions. We don't need to go that far. And we think in light of cases such as the alternative in Congreve and Majesty, that would be difficult. There's something to be said for that actually being the most principled interpretation of the legislation, or on its words. But if one is going to go beyond that, one can see if you've got a single shareholder who's the controlling interest, is the driving force behind it, he brings about the transfer. One can envisage that relatively easily. Once it goes broader than that, these distinctions between active and not become extremely difficult. But we say, come what may, someone like Anne just did nothing, left it to Stephen and Peter. We say the Court of Appeal was right. In any event, she must be out.
At 199, paragraph 199, the first-tier tribunal refer to Anne as entrusting her responsibilities to Stephen and Peter and happy to go along with their decisions. And they go on to say that Stephen and Peter were acting under the authority of Anne in relation to her directorship and shareholder functions. What do you take that to mean?
So that's the passage which the Court of Appeal said, well, this was their reason for finding that she was she could be liable, but elsewhere they'd made these other comments about no active part in decisions and so on and so forth that I've referred you to. So it seems to me that unless there's no evidence of this, a formal sort of proxy arrangement, some formal entrusting of her voting powers to Stephen or Peter, I don't think it was, as far as I'm aware, I don't think there's any evidence on this, I don't think it's a matter of them voting her shares. It's rather...
Were her shares voted?
Sorry?
Were her shares voted?
No, I think not, my lady.
I thought the relevant transaction was effected essentially on the authority of the board of directors,
yes.
And then someone signed the transfer agreement on behalf of SJA under that authority.
It was signed by Stephen on behalf of SJA and Peter on behalf of SJG. Earlier I may have got it the wrong way around when I said one of them didn't sign it. Only one of the father and son signed it for each side.
Right.
But I think that the point is...
But what wasn't that done under the authority of the board of directors of SJA?
Well, it was done under the authority of the board, but we say that she herself... It's remembering that one has to step back and say, well, this is a provision which applies to an individual who must be a transferor. What is it that she has done, bearing in mind the actual transfer was by a company, to bring her within that? And we say, a starting point, of course, is, and this addresses the problems Lord Reed has raised, you limit it to the controlling shareholder. But if one's gone beyond that, and this is precisely why we say you don't go beyond that, you have all of these nebulous distinctions.
But surely the point about paragraph 199 is you keep saying Anne's done nothing, but the tribunal has found she's done something. She's entrusted her responsibilities to Stephen and Peter.
Yeah. And we would say, reading that, and she's done that, of course, that's what they say. They say she's happy to go along with their decisions, but we would say that's not enough in this alternative world where you have to draw these distinctions. We would say that if you're going to cross that boundary to become a minority shareholder who can be liable, one of a number of transferors, you must yourself have actively done something, been there, stepping back, letting other people do things, even sort of say, well, you can run the business, you have my authority to do it, I'll go along with what you do. We say that's not enough.
Even if you're a director.
Well, that's the point, isn't it? I mean, she is a director with duties owed to the company, and what the FTT have held is that she gave authority to Stephen and Peter in respect of her directorship. So what they seem to be saying is that while there may be no formal proxy, they have construed her behaviour as being conferring authority on Stephen and Peter to act for her in respect of her directorship. Now that clearly is doing something.
Well, it's doing some. I suppose this begs the question: then, well, what something is sufficient to get you over the line if we're in this alternative world? Part of the difficulty in responding to this is that we fundamentally think it's wrong in principle, but for these very reasons. This is why individuals in this category shouldn't be liable at all. But we would say if you've got to be the transferor in reality to be liable under a penal section, I don't think I can put it any higher than that. I don't. These aren't as I say, very nebulous distinctions, which is precisely why we say these sorts of cases shouldn't even be within the realm of 739. But we say if fundamentally you've got to be the real transferor, the wording used by Mr. Justice Walton in Pratt, and you've let other people do things, it's also not quite clear what the FTT meant by authority.
Well, that's what I was asking you. I mean, how do you interpret what the FTT are saying in paragraph 199? They appear on face value to be saying that she conferred agency in respect of her directorship to Stephen and Peter. And no one seems to be attacking that conclusion.
The way I would read that, my lord, is this. I would read that as a family-type situation where you've got certain individuals who are running the business, taking the decisions, doing things. You've got someone else in the family who trusts that the other two will be doing what's right and leaves it to them. So in that sense, they have the authority to do things. And there is that question then, well, is that sufficient?
But it seems to be rewarding a director for neglecting their fiduciary duties by saying, well, you may be a director, but as long as you actually pay no attention to the welfare of the company and don't do anything, you have the advantage that you're not liable for tax, whereas the directors who are more diligent in their duties towards the company are liable to tax.
Well, the flip, I see the point, but the flip, I don't say that would be a dereliction of fiduciary duty by the director letting other, in that family context, letting the father and son, husband and son, take the decisions. But I would say this: if that's sufficient, then it says, in fact, Lord Reed's example, well, what if she deliberately voted against it?
Well, that would
knowing, and it goes back, or what if she'd simply abstained? So,
but we're not in that territory, because what they're concluding there, at least on prima facie reading, is they start by saying that all three were directors and shareholders, and then they say that Anne entrusted her responsibilities. Now, they would be principally responsibilities qua director, because one doesn't have fiduciary duties to the company array shareholding. And it goes on to say that they were acting with her authority in respect of her directorship.
Yeah, I think the way I'd respond to that, my lord, is fundamentally goes back to that point. What is it then that makes you a real transferor? So
that's what I've been trying to get at all morning, to find a principle that's being applied here.
And I think the true principle is if you're the person who controls the company more than 50%, and you then bring about the transfer, you either, most likely you'll be a director in that circumstance and you vote it through. One could take it one step further and you compelled by virtue of your shareholding the directors to take that course of action that you like. That's a transferor.
And you say it doesn't matter that section 739 would then be quite narrow because you've now got section 740.
Quite right. And of course, on its wording, my lady, it doesn't even apply to companies. So one view is, as you say, it'd be narrow, but you've also got 740. The other view is, well, it's more expansive than the literal wording, as it is, but as Lord Wilberforce said in Majesty, bearing in mind its penal provision, it's kept within bounds.
Yes, but that's falling back onto your argument of multiple transferors.
Yeah.
If you were to be wrong about that,
yes,
then isn't paragraph 199 rather damaging to the case of the exclusion of Anne?
Well, it's that. One has to read the FTT's findings in totality, and they also said she took no active part in the decision making.
But that's all completely consistent with 199. There's not a conflict between them. She took no active part because she'd entrusted Stephen and Peter
precisely
to carry out her role.
And the question then becomes, in principle, is that sufficient? And even without falling back, as you say, on my arguments why you shouldn't even be having this debate, we say it's not sufficient. if one is going to extend it to such a broad circumstance, multiple transferors and so on and so forth being liable, then the sensible way of limiting it, we say someone who actually votes in favour of something. Otherwise, we say, because, in a sense, the reasons why we say you shouldn't have multiple transferors, or some of those reasons, apply a fortiori if minority shareholders, if that category gets wider and wider and wider, and we say that voting in favour, actively doing it, not entrusting it or letting your husband and son do it, but you yourself do it, we say you're in, otherwise you're not. Now, the last point, and I'll take this briefly and I can expand if need be.
Mr. Baker is being left very short of time.
Short of time. I can do this in probably 3 minutes, the headline points. It's on the last point made by the revenue, where they say Vesti no longer holds good. And I'll very, very briefly touch on their 3 reasons.
And so, sorry, where do they say that?
They say that at paragraph 43 onwards. It's the end of their issue 1 discussion. Sorry, paragraph 41, I think. Sorry, not 43.
No, 43, I think is right.
Oh, it is 43, page 74 of the key bundle. And they've essentially got three arguments. They start by noting that the House of Lords in Vesti drew a distinction between such an individual either means an individual ordinarily resident in the UK or an individually ordinarily resident in the UK who sought to avoid tax by a transfer of assets abroad. And they say, well, it's never been a requirement that a purpose of the transfer was to avoid income tax. They say that's made express in subsection 1AB, but they say Vesti can only apply if the transferor had a motive of avoiding income tax. So they say, well, therefore Vesti must be wrong. And I said there's 2 answers to that I can give quite quickly. The first is, well, for HMRC to be right, it must either be the case that the House of Lords in Vesti said you're only a transferor if you have tax avoidance motive. Well, they didn't say that. That's nowhere in Vesti. Or the other basis on which HMRC could be right on this proposition is if there's something in the reasoning of the House of Lords which means their view was you're only liable under 739 as a transferor if there is an income tax avoidance motive. But there's nothing in the decision which makes that an essential ingredient to be a transferor. It's not an essential limb of their reasoning. That they're not saying the reason we are limiting 739 to transferors is because there must be an income tax avoidance motive and therefore we're limiting it to transferors. They don't say that. So neither do they say a transferor can only exist if he or she has an income tax avoidance purpose, nor do they rely on it more broadly as an essential factor in their reasoning. And very briefly on that, what they say, in fact, is such an individual either refers back to just an individually ordinarily resident in the UK, that's the first part of the preamble, or it's the more expansive phrase, individually ordinarily resident in the UK who seeks to avoid income tax by means of transfer of assets. And even if, to the extent that they thought at that stage, because this was before subsection 1AB, that you had to have an income tax avoidance motive, that would have been based on the words in the preamble referring to seeking to avoid income tax liability. But the decision in Vesti that you must be a transferor wasn't based on those words, it was based on the by means of transfers of assets. So the Revenue's argument that Vesti Vesti requires a transferor to be someone who holds an income tax avoidance motive is simply wrong. So that's not a reason for doing away with Vesti. The second reason is they say that the spousal extinction makes no sense. It was never good law. Well, that's not true. So if non-transferors can be liable, as was the position under Congreve, the spousal extension isn't actually required because the person who has power to enjoy can be liable, whether he transferred or not. So you don't need to ascribe the spouse's power to enjoy to the other spouse. By contrast, under Vesti, if 739 is limited to transferors, then the spousal extension is important, because if one spouse, let's say the wife, transfers and the husband has power to enjoy, you either treat the wife who's transferred as having the power to enjoy, or you treat the husband as also making the transfer, but it's only in that context that the spousal extension makes sense. The revenue says, well, here's an example. Let's say the wife is UK resident and the husband is non-resident. She transfers assets abroad. The husband has power to enjoy, but he can't be liable because he's non-resident. So they say that demonstrates that even if you're in the pre-vesty world, where it's not limited to transferors, nonetheless, spousal extension has a relevance. It's dealing with wife being UK resident, husband being non-resident, he has power to enjoy, and it's a way to make her liable in relation to his power to enjoy. Well, that's wrong, and the reason is there's no tax avoidance in that circumstance. In that example they give, there's no tax avoidance. So A, it's fanciful to suggest that's why the spousal extension was introduced. And B, you'd expect the motive defence to apply anyway, so the spousal extension wouldn't achieve anything. So assume you've got a foreign asset, UK resident wife, she could just give the foreign asset to her non-resident husband. He wouldn't be liable on any income arising from that asset because it's a foreign asset, he's non-resident. So the fact that she then transfers it to someone else and he has power to enjoy doesn't involve any income tax avoidance. She could have just given it to him. It's a foreign source asset, he's non-resident, there wouldn't be any liability. So that example they give doesn't even involve avoidance, so it can't have been the reason for the spousal asset, but spousal extension. Equally, if it was a UK source asset, well then transferring it to a person abroad doesn't achieve anything, because whether you're abroad or not, if it's a UK source asset, you're liable on the income arising from that asset. So whether it's a foreign asset or a UK asset in question, in their example, there's no tax avoidance, so the spousal extension can't have been introduced for that circumstance, and it certainly doesn't achieve anything because you'd expect the motive defence to apply. Instead, as Vesti said, the House of Lords said in Vesti, the reason for the spousal extension is precisely because 739 only applies to transferors. It's not the case that the three different lords who expressly discussed spousal extension in Vesti were all wrong. And the final point they make, the final one I'll be addressing, is they say that HMRC, they say that the House of Lords in Vesti relied on the absence of apportionment machinery. They say this was the most important point in Vesti, but it's been dealt with by 744. There's three answers. One, I don't think this was the most important point in Vesti when you read it, but that's by the by. The second point is, as I've already said, the introduction of 744 can't extend the scope of the charging provisions. But the third point, and it's an important point which the revenue overlook, is that here they're not saying 744 means you can have multiple transferors liable. What they're saying is the introduction of 744 means Vesti is no longer good law. Non-transferors can be liable. That obviously can't be right, because if 744 could make non-transferors liable, Parliament wouldn't have introduced 740 at the same time. Those, my lords, my lady, are my submissions. If I can assist you further, I'm happy to, and if not, my learned senior will proceed.
Thank you very much, Mr. Rafsal.
Thank you.
Mr. Baker.
Lord Lady, I'm turning to the motive defence. I will have to be very brief. You have our written submissions, and so I'm going to be very selective there. First point is there's a misstatement in the Revenue's written case. Paragraph 49, they say that Fishers now accept they cannot satisfy the first limb of the motive defence. Remember, there are two limbs of the defence, and that is not correct. We do not accept that we cannot satisfy the first limb, and many of our arguments relating to the meaning of taxation, distinction between tax avoidance and tax mitigation, they all go to both of the limbs of the defence. In paragraph 24 of our written case refers to both limbs. What we have done is to focus on the second limb, which is the limb that relates to bona fide commercial transactions, because for that limb and the FTT found that this was a bona fide commercial transaction, it is only necessary to establish that the transaction was not designed for the purpose of avoiding liability to taxation. And the case of Carville, which I will take you to later, emphasizes that it has to be designed for the main purpose of avoiding liability to taxation. If this is a bona fide commercial transaction, it is therefore easier to satisfy the second limb. We are focused on that both before the upper tribunal and the Court of Appeal. For example, page 106 of the upper tribunal, page 186 of the electronic bundle. So that is not correct. We make 4 substantive submissions with regard to the motive defence. The first of those is that betting duty is not taxation, and that the case of Sassoon is not good authority on this point. The transfer of asset provisions have always been included in legislation relating to income tax. They impose a charge to income tax on income arising to a person abroad. It's entirely rational and consistent with the purpose of the legislation that if an individual seeks to avoid income tax, then they should be subject to an income tax charge, and they should be excluded from the charge if they can show they had no purpose of avoiding liability to income tax. The whole context of the legislation is that of income tax avoidance, and so taxation in the motive defence should be restricted to avoidance of income tax. That is particularly supported by the statement explicit in the legislation of the purpose of the legislation. From the time it was introduced in 1936, there was a preamble to the legislation which you have seen for the purpose of preventing the avoiding by individuals ordinarily resident in the UK of liability to income tax by means of transfer of assets. That's a statement of the parliamentary purpose behind the legislation. The purpose is to prevent the avoidance of liability to income tax, and therefore it should be possible to prove no main purpose of avoiding income tax. Any other taxes are not within that purpose. Yeah.
I wonder about that. I was also looking at the 1936 Act, which is page 1730
Yes.
in our bundles. And the motive defence came in originally as a proviso to section 18.1.
Yes.
And at first blush, it does look as though the drafter has very deliberately shifted from the language of charge to liability to income tax in the preamble, as you describe it, and then in subsection 1, reference to would not have been chargeable to income tax. And then you go into the proviso, and it's a proviso because this is just the conditions to be satisfied if you're to escape the charge to tax, where they say a transfer and any associated operations were effective mainly for some purpose other than the purpose of avoiding liability to taxation.
Of course.
Now, if it's that difference of language is in the very same provision, doesn't that tend to indicate that the word taxation is intended to have its natural meaning? Not
With respect, no, my lord. If the draftsman had intended it to cover all forms of taxation, he could have done so very easily by saying that it's all taxation, and in fact subsequent legislation since 2005 has actually said that. We say that that change in the law is irrelevant, and the legislation is in a provision dealing with only income tax, and the purpose of Parliament to prevent the avoidance of income tax is stipulated there. So the word taxation is not, it's not explicit that it says income tax, equally it's not explicit the other way. And therefore, this is a circumstance where the meaning of the legislation is unclear. In those circumstances, it's appropriate to have a regard to the context and to the purpose of the legislation. And the purpose of the legislation is expressly stated to be to prevent the avoidance of income tax. If you extend it to other taxes, then, as we say in our written case, the results are entirely anomalous and, in some cases, entirely unfair, because the amount of the charge to tax under 739 bears no relationship whatsoever to the amount of the tax, whatever it may be, that has been avoided. It may exceed many times the amount of the other tax that's been avoided. The other tax may even have been abolished, and yet the charge under 739 is said to continue. The circumstances here are exactly that. The charge to betting duty was removed in October 2001, and a different form of taxation was introduced. Nevertheless, it's said that the charge under 739 continues throughout the whole of the 8-year period that the Fishers owned the shares, because they could not show they could show that the purpose of avoiding income tax was not their purpose, but they could not show that the purpose of avoiding any other tax, particularly betting duty. So even though betting duty had been abolished, the tax charge continued there. That's an anomalous result, we say, particularly for a provision that is penal. And that makes you liable on tax that is not your income, it effectively makes Section 739 and Section 740, because the motive defence applies to both of them, a general anti-avoidance provision, not a provision with the purpose of preventing the avoidance of income tax, but if you cannot show that there was no purpose of avoiding any tax whatsoever, then the motive defence is not available to you. And I should have stressed at the outset, the motive defence is absolutely fundamental to this legislation. This is legislation that has been broadened over the years. It applies to transfers by a non-resident. It applies to transfers made to a person who is resident but becomes non-resident. There is no longer a requirement to show that there was a purpose of avoiding income tax. The motive defence is absolutely critical, and that's why, for example, it's particularly unfair in the circumstances of Anne that specific finding that she had no motive, but she cannot rely upon the motive defence because the purpose of the transfer is determined by having regard to Peter and Stephen, and Peter and Stephen are not unable to say, we did not seek to avoid income tax, which is something that the First Tier Tribunal found, but nevertheless they found that there was said to be a purpose of avoiding other betting duty. The revenues argue that the introduction of Section 7391AB, which provided in 1997, when it was enacted, that the avoidance of liability, it's not necessary to show the avoidance of liability to income tax is the purpose, or one of the purposes for which the transfer was effected. They say that that makes all the difference there, because how can it be that it is no longer necessary that the avoidance of liability to income tax should be the purpose of the transfer, but that misses the point completely. It is not necessary to show for the revenue to bring liability that the transfer was effected for the purpose of avoiding liability to income tax, but what was the preamble, what is now Section 1, the purpose of Parliament in enacting the legislation to prevent the avoidance of income tax, that was not changed. So all that has happened is that it is no longer necessary for the revenue to show that there was a purpose of avoiding income tax, but the purpose of the legislation is still the avoidance, to counter the avoidance of income tax, and the motive defence was not amended in 1997. So it is still possible for the taxpayer to show that the avoidance of income tax was not the design of the main purpose of a bona fide commercial transaction. We did not argue this point below because of the case of Sassoon, which is is Authorities 1410, what we say about Sassoon is this: there are a number of factors that reduce the authority of Sassoon. The case was not argued below in the High Court. The case was only argued by counsel for the taxpayer. Only 2 Lord Justices took part in the case, and the case has a very strong wartime sense that the Court of Appeal was concerned to impose liability on those who, in the terms of the Court of Appeal, shirk their responsibilities to taxation. But our main criticism of Sassoon is that it has virtually no rationale, no reasoning. It followed a case of MacDonald, which is at page 1400. In Sassoon, the Court of Appeal does not discuss at all why the reasoning for MacDonald may be incorrect there. They don't analyse that. They quote the preamble and the purpose of the legislation that I referred you to, but do not deal at all with the fact that what they are saying by limiting the defence to all taxes conflicts with that apparent purpose of Parliament, and they do not deal at all with any of the consequences of that. And then at paragraph 8, in the judgment at page 1412, and I won't take you to that, but it's a paragraph 85 of our written case, they say it's important to bear in mind on the question of interpretation that the subsection is retrospective to this extent, and that appears to be part of the reasoning of the Court of Appeal, that the legislation was retrospective. It's retrospective to the extent that it applied to transfers made before the 1936 Act came into force. But there's no obvious reason why retrospectivity has any bearing whatsoever to the scope of the motive defence there. So for reasons that are elaborated in our case, we say that Sassoon is not, it's not binding authority on your lordships, it's not even persuasive authority. The only reason it is given retrospectivity appears to have no bearing whatsoever on the meaning of the legislation. In their written case, HMRC say that Sassoon, which was decided in 1943, legislation has subsequently reenacted the wording in the motive defence, and they refer to the Barras principle that where legislation has subsequently been reenacted by Parliament, the Parliament has adopted the meaning of previous case law. However, what the review ceased to do not note is that the legislation they refer to, which is the Income Tax Act 1952 and the Income and Corporation Taxes Act 1970 and 1988, they were all consolidating legislation. And Benyon on statutory interpretation, and that's at Authorities 3132, makes it clear that the Barras principle does not apply to consolidating legislation. The revenue in their case do not respond to the reasons we set out in paragraph 86 why Sassoon is unpersuasive. They primarily rely upon the Barras principle, and we say that that cannot apply here for the reasons that Benyon sets out. Our second substantive argument relates to tax mitigation. The distinction between tax avoidance and tax mitigation is best seen in the speech of Lord Nolan in Willoughby, and that's quoted at paragraph 90 of our written case, where Lord Nolan accepts a submission that tax avoidance is to be distinguished from tax mitigation. The hallmark of tax avoidance is that the taxpayer reduces his liability to tax without incurring the economic consequences that Parliament intended to be suffered by any taxpayer qualifying for such reduction. The hallmark of tax mitigation, on the other hand, is the taxpayer takes advantage of fiscally attractive option afforded to him by the tax legislation and generally suffers the economic consequences the Parliament intended to be suffered. In this case, the Betting and Gaming Duties Act provided for two possible regimes. Bookmakers in the UK were subject to the regime of charging betting duty. Those abroad were never liable to charge that tax, but they were liable to the restrictions in Section 9 of the Betting and Gaming Duties Act. The Fishers accepted that in order to compete with the unfair competition, which was referred to as Victor Chandler, their only opportunity, having failed to persuade the UK government to change the law, was to go abroad and operate abroad. But when they did so, they were subject to the restrictions in Section 9 of the Act. They accepted that, and they did not use teletext until the Victor Chandler decision. They were then advised, both by Customs and Excise and by leading counsel, that in order to comply with Section 9 and not risk potential criminal liability, they needed a separate company. And that was the reason for the transfer that took place in February 2000. Note here, please, the difference in the timing. By July 1999, SJA was operating to provide telebetting from its branch in Gibraltar and had, in a sense, solved the question of saving its business because it could offer telebetting to UK punters, but it was subject to the Section 9 restrictions. They were then advised that to comply with those restrictions, they needed a separate company. They then made the transfer some 8 months later, by which time they were already operating overseas and offering duty-free betting. And it's that transfer in February 2000 to which it is said that Section 739 applies. The reason for that transfer was to comply with Section 9. And that was accepting the consequences of operating offshore, its tax mitigation. It's accepting that there is a separate regime, but Section 9 applies. Now, the first-tier tribunal, and with respect to the Court of Appeal, wrongly confuse this for two reasons. Firstly, they fail to distinguish the commencement of activities in Gibraltar, which was in July 1999, at which point in time the company, in a sense, was put on the track of saving and non-duty betting was available. They confuse that with the transfer in February 2000, which is the one to which Section 739. And they say, well, the Section 9 issue is all bound up with the avoidance of betting duty. But with respect, that cannot be correct, because the avoidance of betting duty, if it is avoidance, it's making provision for punters to bet without paying tax, that had taken place 8 months earlier. The transfer in February of 2000 was for the purpose of complying with Section 9, and when the FTT conjoins those two together, they make an error of law. This is not an error of fact that we are challenging. We cannot challenge that. They make an error of law in failing to identify the correct transfer. They make a second error of law, and this is our third.
I ask you about the distinction between tax avoidance and tax mitigation. Is the taxpayer involving himself in the loss or in loss or expenditure, which entitles him to make a deduction? What's the loss of an expenditure here?
The expenditure here was the additional cost of setting up in Gibraltar with a separate company.
And was
they had
that
to
a- was that a
incorporate the
recurring
company.
cost?
They had to transfer employees to that company. They were no longer able to operate through the branch, and they were unable to advertise until the Victor Chandler decision. They incurred themselves in the additional cost of complying with that, and they accepted the restrictions. In any event, I'm not certain that tax mitigation can be said only to apply in circumstances where there is a deductible cost incurred. It's where Parliament offers essentially a tax-free opportunity. Here, the opportunity to bet without, to provide betting without duty, but imposes conditions upon that. And the taxpayer accepts those conditions. And the conditions here were in Section 9, and it so happened that that also resulted in costs being incurred by the costs being incurred by the Fisher family in setting up the company in Gibraltar. So there was an actual cost of doing so. Our third submission.
I wonder if we might hear your third submission after a short.
It will have to be at a gallop, my lords. Regrettably, this case was originally set down for 2 days, and you have asked us to complete within a day and a half, and we have tried our best to do so. I don't know whether your lordships would consider.
Yes, we can consider that over the adjournment.
Thank you very much.
We'll sit again at 2 o'clock.
Thank you.